Hello everyone, a very good morning and welcome to BYJU'S Exam Prep. Welcome to the daily Hindu news analysis. So let's begin the discussion by looking at the topics we are going to cover today from the Delhi edition of the Hindu newspaper. I have chosen a total of 7 important articles, 3 important columns and articles for your mains examination and 4 smaller articles which are relevant for the prelims exam. So let's cover all these topics in complete detail so that you don't have to go back and read the newspaper again. If you guys are benefiting from the initiative, do let us know through your comments, press that like button and do subscribe to the channel. So let's begin with the first article which is present on the last page of the online edition of the Hindu newspaper. On page number 2 of the supplement, we have this important article that deals with abortion laws in India. It deals with the topic of abortion because of a recent case that came up at the Supreme Court. In this particular case, where a pregnant woman who was 26 weeks pregnant was appealing in front of the Supreme Court asking for approval for legal termination, medical termination of her pregnancy. This request was rejected by a 3-judge bench of the Supreme Court, which was headed by Chief Justice of India, D.Y. Chandrachud. The pregnant woman was requesting permission under the Medical Termination of Pregnancy Act, also popularly known as the MTP Act, to terminate her pregnancy on certain grounds. The argument of the pregnant woman was that this was an unplanned pregnancy. The couple didn't plan for this pregnancy and they already had 2 children. So the woman argued that she is suffering from postpartum depression, which is quite common amongst women who have given birth. Her argument was she is suffering from mental illness, suffering from depression and anxiety, and also financially the family is not strong enough to take care of a 3rd child. As they already have 2 children, the family is not economically well off. She was arguing that the family is not capable of taking care of the child. It was an unplanned pregnancy, plus she's suffering from mental illness. So physically, emotionally, financially, and even mentally and medically. The mother's argument was that she won't be able to carry, deliver, and raise this child. So this particular case has been quite interesting. It has raised many legal issues, and the Supreme Court eventually has rejected the request. And it has brought up the debate between women's reproductive rights and the bodily autonomy of women to decide on their pregnancies and the right of the fetus, the right of the unborn child. Because in this particular case, the Supreme Court has made a mention of fetal viability and the rights of the fetus or the unborn child. Now, this is quite rare in India's legal landscape because India does have one of the most progressive laws when it comes to abortion. Compared to many other countries, even developed countries, even if you look at Western nations like US and European countries, they have very conservative laws regarding abortion. In the United States, for example, where in certain states religious conservatism is very high, there are laws that criminalize abortion. Abortion is entirely illegal in several parts of the world, which triggers a debate between pro-choice and pro-life. Those who are pro-life are usually the more conservative elements, the more religious elements, who accord more preference for the fetus, the unborn child, on the basis of right to life. So naturally they oppose abortion. They even support criminalization of abortion. But the more progressive individuals, they are pro-choice, meaning women should be given complete autonomy over her body and over her reproductive rights, including the decision to get pregnant and to carry the child and deliver the child. Under certain circumstances, a woman should exercise her reproductive rights to terminate the pregnancy if required. Is that clear? So, compared to many other countries, with regard to the debate between pro-choice and pro-life, India is much more progressive than even Western countries and advanced developed countries. We have a very progressive law, the MTP Act, the Medical Termination of Pregnancy Act, which has always been very liberally interpreted by our courts. The Indian judiciary has always given a very progressive liberal interpretation. The law itself is very progressive and it tilts towards women's reproductive rights. If it comes to the debate between the right of the fetus or the unborn child and women's reproductive rights and bodily autonomy, the Indian law and the Indian judiciary have always favored the bodily autonomy of women. So in India, generally, women's reproductive rights has been upheld even at the cost of the right of the unborn child. Now this case marks a departure. This particular case and the final ruling of the Supreme Court is a departure from the established precedent. And that is why the topic becomes very, very important. We need to understand what are the abortion laws in India, right? What legal provisions do we have? What are the details of the MTP Act? And what makes this law one of the most progressive abortion laws in the world? Now in India, before 1971, before the MTP Act was enacted by the Parliament, under Section 312 of the Indian Penal Code, which is of colonial origin, abortion was criminalized. Naturally, a colonial law, you can't expect that to be progressive. You can't expect a colonial law to respect the reproductive rights of women. So, under this law, abortion had been criminalized. If voluntarily miscarriage was caused, either by the pregnant woman or with the help of a medical professional, right, this would be a prosecutable offense. This was the legal status in India. Essentially, abortion was illegal. It was a criminal act. But because of the criminalization of the practice, it led to women having several dangerous, unsafe abortions. Because in many cases of pregnancies, right, there could be complications involved. For example, a woman might have got pregnant either due to rape. She might be a rape survivor, a rape victim. You can't expect the woman to bear the child if she doesn't want to in such heinous cases. Or the pregnancy might be forced or unwanted. So keeping in mind the well-being of the mother and also the unborn child, it is always better to respect the choice of the woman and allow her to exercise the right whether to bear the child or not. So in India, there was a realization by 1970s that criminalizing abortion was leading to more dangerous practices as women were resorting to unsafe, dangerous methods of abortion. It had created an entire illegal industry where these illegal shady clinics and few doctors would carry out abortion illegally, putting the life of the mother and even the unborn child at great risk. So to address the issue, India decided to liberalize access to abortion to reform the entire legal landscape. And this progressive, forward-looking legislation was brought out. The MTP Act, the Medical Termination of Pregnancy Act. It liberalized access to abortion and clearly recognized the reproductive rights of women. It allowed termination of pregnancy under certain circumstances, under certain conditions with very strict checks and balances. Medical termination of pregnancy was legalized in India and it was allowed under two stages. In the first stage, where the pregnancy is 0 to 12 weeks from conception, pregnancy can be terminated with the opinion of one doctor. In case of unwanted pregnancies or forced pregnancies, including rape, etc., or even in case of mental and physical health issues, right, where it has been determined that the child might have a physical, mental disabilities, right, under certain circumstances, within 0 to 12 weeks, without conditions, the pregnant woman can seek the abortion based on the medical opinion of one doctor. Alright, this was the legal provision that existed before. The second stage was for pregnancies between 12 to 20 weeks. Now that the fetus is more grown, almost viable to the point where the fetus can live outside the womb under medical support, right? It requires the opinion of two doctors to terminate such pregnancies. Because here the risk involved to the mother is much more higher. So under certain conditions, whereas in the first case, it would largely be without conditions if the pregnant woman wants to exercise the right to abortion, right? Based on the opinion of one doctor, the abortion will be carried out. But in the second case, certain conditions have to be met. If there are proven physical, mental abnormalities, if there is a substantial risk to the child and the mother, right? Or if it is a forced unnatural pregnancy. In such cases, for 12 to 20 weeks of pregnancy, with the opinion of two doctors, the termination could be carried out. This was the previous law that existed until 2021. Because in 2021, the law has been amended. Through the MTP Amendment Act passed with the Parliament, a further reform was carried out and a more progressive provision has been added. Now, abortion can be allowed in 3 stages. And the abortion window, which was restricted to 20 weeks maximum, has now been extended to beyond 24 weeks as well. Is that clear? So, as of now, in the first stage, up to 20 weeks, pregnancy is allowed without conditions, with the advice of one doctor. For pregnancies between 20 to 24 weeks, under certain specified categories, there are 7 specific conditions, 7 categories that are mentioned. If these criteria are met, then with the opinion of 2 medical practitioners, 2 certified doctors, the pregnancy can be terminated. Then beyond 24 weeks, when pregnancy is almost towards the end of the gestation period, then with the consent of a medical board constituted at the state level, the pregnancy may be terminated, but the decision is left to the medical board entirely. Is that clear? So in the first stage of pregnancy, the woman has full autonomy. Without conditions, without any pressure from either the legal system or the family, a pregnant woman can opt for abortion without questions asked. Right? This is how the reproductive rights of women and bodily autonomy of women is protected. Beyond 20 weeks, where the medical complications increase, right? So for 20 to 24 weeks, 7 specific criteria are laid down. Only if those conditions are met and certified by 2 doctors, then termination is allowed. But for beyond 24 weeks, the decision is entirely left to the medical board. At the state level, there are medical boards constituted which take a call depending on all the factors of the case, all the conditions of that particular case. Now, what are these conditions under the second stage? What are the conditions under which pregnancy can be terminated during the second stage, that is 20 to 24 weeks of pregnancy? There are 7 specific categories. One in case of victims of sexual assault, rape or incest. This is a clear case of forced pregnancy, right? So you can't force the woman to have the child if she doesn't want to. If the pregnancy is a result of rape or sexual assault or an incestual relationship, right, then the mother can exercise the right, and with the approval of 2 doctors, the pregnancy can be terminated even after 20 weeks, up till 24 weeks. In case of minors, if minor children have gotten pregnant, either due to unsafe sex or again due to rapes and sexual abuse, right? Even in that scenario, the termination will be allowed. The third condition is change of marital status. That is, after getting pregnant, if the couple get divorced or if the husband passes away, right, which leaves behind a pregnant widow, then the pregnant woman can opt for termination of pregnancy on these grounds as well, if the marital status changes, either because of divorce or widowhood. But however, it doesn't take into account the status of unmarried women. That is not very clearly specified here in the law. Next, women suffering from physical and mental disabilities. If they have major disabilities as recognized under the Right of Persons with Disabilities Act, or if they are suffering from severe mental illness, which is certified by the health authorities, by the doctors, even in such cases, termination will be allowed. Then if there is a proven fetal malformation, if the doctors certify that the fetus has developed an abnormality, a genetic or a hereditary abnormality, which could lead to physical, mental abnormalities in the child if it is born, right, which will handicap the child forever, which places a burden on the unborn child going forward in the future, and also on the parents in the family and the society. So such fetuses can also be terminated in case of proven physical, mental abnormalities. And finally, if pregnancies come up during emergencies, disasters, in a humanitarian setting as declared by the government, women who are affected by such events can also claim termination for their pregnancy. Right? A region hit by disasters, war, conflict, wherever a humanitarian situation has arisen, and if the pregnancy was unwanted or if the pregnancy can't be taken forward, if the woman is in no position to look after the child after giving birth, in such cases as well, termination can be sought. So these are the 7 specific conditions for the second stage of termination. So here as well, women has certain reproductive rights and certain autonomy over her pregnancy. But in the first stage, the woman has complete autonomy. The woman can exercise the right without conditions. But in the third stage, the matter is left entirely to the medical board. Now, let's look at this current case which has come up where the controversy has erupted. A couple of weeks ago, this pregnant woman who was almost 24 weeks pregnant had approached the Supreme Court asking for termination of pregnancy on the grounds that it was unwanted, that the contraceptive methods had failed. The couple never wanted the child because they already had 2 children. So they never wanted the third child, and despite using contraception, it had failed and it was an unwanted pregnancy. And also, the pregnant woman pointed out to the Supreme Court that the family is not capable of taking care of the child, both economically and even mentally and emotionally as well, as the mother is suffering from postpartum depression after the second childbirth. So based on these grounds, the 2-judge bench headed by Justice Hima Kohli and B.V. Nagaratna, they had permitted the termination to take place. They had allowed for the termination, saying that unwanted pregnancy is as good as forced pregnancy. Since contraceptive failure was established, the judges ruled that this is as good as forced pregnancy. If the mother doesn't want it, the mother can terminate it. So permission had been granted. But then, the concerned doctor from AIIMS Delhi wrote back to the court and the council of the central government asking permission for feticide, meaning to ensure that the fetus is killed before the termination of pregnancy. Right? To stop the heartbeat, which has already started, permission was sought by the medical team at AIIMS before the termination can be done. In this report, the medical team wrote that the fetus is currently viable. The fetus has reached viability, meaning it has a strong possibility of survival even if taken out of the womb and given the right medical support through incubation. Today, medical technology has advanced. By using incubators, fetuses in such advanced stages of pregnancies can be allowed to survive outside of the womb as well. So the medical team wrote that the fetus is viable. Fetal viability has been established, meaning the fetus will survive outside of the womb. So we need permission to carry out feticide, meaning we need to stop the heartbeat before carrying out the termination. Now this led the Supreme Court to take a relook at the decision. The 2-judge bench of the Supreme Court now was split. The 2 judges, they were divided in their opinion, while Justice Nagaratna said that the pregnant woman still has a right over her bodily autonomy. She still exercises her reproductive rights and she can go ahead with the termination. But Justice Kohli said her judicial conscience will not allow her to permit this termination. Now that the doctors had said the fetus is viable, meaning it's going to survive if given a chance, the other judge refused to agree, and as a result, it was recommended to a 3-judge bench, which would be headed by Chief Justice D.Y. Chandrachud. So the 3-judge bench has ruled that the medical termination cannot be allowed. Now that fetal viability has been established, medical termination will not be allowed by the Supreme Court, which means the woman is forced to bear the child right now. So this is what brings up the question. What is fetal viability? What's the legal basis for that? Then what about the right of the unborn child? What does the law say about the right of the unborn child? How does this affect the reproductive rights of women? This is what you need to understand. Is that clear? Now, if you look at the concept of fetal viability, it was first brought out in the United States in a landmark case related to abortion, which is the Roe versus Wade. In 1973, the US Supreme Court declared that abortion is a constitutional right until the point of fetal viability. Is that clear? The Roe versus Wade case is a landmark case. It has been in news recently as well, because in the US there is a divided opinion with regard to the debate between pro-choice and pro-life, right? In the US, the public and also the judiciary, the government is divided on the topic of abortion. So Roe versus Wade judgment was seen as a historical judgment that recognized abortion as a constitutional right, and thus it had upheld women's reproductive rights and their right over bodily autonomy. But abortion in the US was provided as a constitutional right until the point of fetal viability, beyond which abortion cannot be exercised as a constitutional right. Meaning, if the fetus can survive outside the womb with medical support, if that can be established, then medical termination will not be granted. So anything before that, before the fetus reaches the point of viability, before that, termination will be allowed. So in the US, this legal concept was brought out. Now, while passing the recent judgment, the Supreme Court of India has observed, see, we need not go back to the controversial debate surrounding Roe versus Wade in the United States. We need not draw any lessons or any precedents from foreign jurisdiction, because the Indian law, as I told you earlier, is one of the most progressive abortion laws in the world. It's very liberal, progressive, pro-choice, and respects the autonomy of women. It largely provides the women with the rights to decide about the pregnancy. Is that clear? So in that regard, the Indian law is very progressive. The courts have always read the act liberally as well. As I was mentioning, in previous cases, there are cases where pregnancy termination has been allowed in 27, 28 weeks as well, even after 26 weeks. So there is a precedent where the Indian judiciary, from lower courts to Supreme Court, have always given a liberal interpretation, which means they've always respected the reproductive rights of women and the bodily autonomy of women. But this is the first time the concept of fetal viability has been used in the case of India. The three-judge bench, which was driven by the medical report that said the fetus is now viable, based on that, the Supreme Court bench has ruled that fetal viability has been established and hence we cannot allow the termination to be carried out, which means the Supreme Court is talking about the rights of the unborn child, which was not recognized previously. Now see, here there is a problem. There is a major issue with this. Now, fetal viability is a very abstract concept. It's not very clearly defined as to at what point fetal viability begins. Because with advancement in medical sciences and technology, today it is possible to make the fetus survive even at 23, 24 weeks of pregnancy outside the womb with the help of medical incubatory support. Right? Now, the law is allowing termination even beyond 24 weeks. In that case, if fetal viability is getting established at 23, 24 weeks itself, in a way it tramples upon the rights of women to get the pregnancy terminated. And also, medically, there is no established standard as to when fetal viability begins. It varies from case to case and also depends on the medical support available to that pregnant woman. So as it is a very arbitrary standard, a very abstract concept, right? It has never been used in Indian law before. So there is a clear legislative gap over here, which this case has brought up. Right? We have never used the concept of fetal viability. The Supreme Court, the judiciary has never applied it in India. But using it for the first time is a new interpretation. And this raises questions about reproductive rights of women. Is that clear? There is a criticism of the MTP Act that after 20 weeks, that is in the second and third stage, the decision is largely left to doctors and not to the woman. Right? As I told you earlier, in the first stage of termination, that is up to 20 weeks, the pregnant woman has full autonomy. Without conditions, without any pressure from anyone, the pregnant woman can opt for termination without questions asked. Until then, women have reproductive rights and full bodily autonomy. But beyond that, doctors are playing a bigger role. Of course, the other argument is that as the complication increases in the pregnancy, doctors' opinion becomes critical to ensure the safety of the mother's life, and also the life of the unborn child. So this is where a criticism exists, that there is a gap in our law. There is a legislative gap. So we need to address this issue before more complicated cases come up in the future. Now, what about rights of the unborn child? Is it recognized in India? The answer is actually no. With regard to abortion, if you are just talking about abortion, medical termination of pregnancy, the right of the unborn child is not recognized in India. That is why India's legal framework is completely pro-choice and not pro-life. Pro-life is a very conservative concept, a very orthodox concept. So the Indian legal framework does not really recognize the right of the unborn child. Women's autonomy is given priority over rights of the unborn child. That's what makes the law progressive and liberal. In fact, in 2005, there was a petition challenging the constitutional validity of the MTP Act. The petitioner, in the Nandakishore Sharma case, had argued that MTP Act is against life. It violates the fundamental right of the unborn child, which is right to life guaranteed under Article 21. And hence the petitioner was arguing the law itself is unconstitutional. But the Supreme Court rejected this argument. The Supreme Court, and in this particular case the State High Court, the Rajasthan High Court, rejected this argument and upheld the constitutional validity of the law, which clearly showed that right of the unborn child is not recognized in India. Is that clear? It is recognized, however, in other matters, not related to abortion. For example, with regard to succession, the succession inheritance laws, with regard to property inheritance. Then with regard to sex determination and feticide. In such cases, the right of the unborn child is recognized, which has nothing to do with abortion. Alright? Even under the CRPC, under section 416, if death penalty has been awarded to pregnant women, it can be postponed until the woman can deliver the child in order to uphold the right of the unborn child. So, right of the unborn child in India is recognized only under CRPC in case of pregnant women who are awarded the death penalty, where the death penalty is postponed to ensure the fetus is born, the right of the child is protected, and in case of succession and laws related to sex determination and feticide. So these laws have nothing to do with abortion and termination. If you're just looking at abortion and termination, right of the unborn child is not recognized in India. Is that clear? But for the first time, the Supreme Court has given validity for fetal viability in this case, and even it has spoken about the right of the unborn child. So this highlights the legislative gap, right? And it could lead to many such complicated cases where the pregnant woman, right, might compromise her rights over her bodily autonomy. So this is where further debates are needed, and legal intervention is needed through the parliament, through the government, and of course through the judiciary as well, to provide more legal clarity on this particular issue. So this is something you need to understand. It's a very complex issue, a very sensitive social issue as well. So I feel it's very, very important for your mains exam, for both GS1 and GS2, and you can even expect an essay topic, right, or even a in-depth interview question asking your views about medical termination and the laws in India. Now let's look at the next article on page number 12. We have an article referring to caste-based census. In the last few weeks, caste census has been making a lot of news. So the article is examining the significance, the impact of caste census. Of course, the article is specific to the context of Tamil Nadu here. It is examining caste census in Tamil Nadu and its impact on reservation policy. So all the specific details are not relevant for our exam. But there are some key points that we can take away from this article. So let's discuss based on that. The reason why caste census is in news is because in Bihar, recently the state government published the data related to its caste-based census, the socio-economic caste census. So this has brought out data for the first time in Bihar, highlighting the caste-based divisions in the society. It gives a great insight into how caste can play a role in the social and educational and economic status of an individual. So based on this data, now governments can go ahead and provide for additional reservation for certain communities, maybe for certain OBCs, other backward classes, right? So as a result of this new development in Bihar, the topic has become a national rage. It's become a very sensitive political topic as well, because political parties, they largely win elections based on their electoral promises, specifically with regard to reservation. Right? By playing caste politics, by promising reservation for one community against the other, usually political parties in India, both regional and national parties, have fought elections. So it's a very sensitive, delicate political issue as well, along with being a constitutional issue. So the Bihar caste census has triggered this nationwide debate. Across the country, there is a call for similar census to be conducted in different states. So there are many who are supporting it, as it gives more insight into caste-based divisions in the society. Accordingly, then reservation can also be provided to different OBC classes. However, there is a strong opposition against it as well. There is a fear that caste census will lead to breaching the 50% reservation cap, which was laid down by the Supreme Court in 1992. It has also triggered questions about national integrity, about increasing caste divisions in the country, as it's an electoral issue, right? It could be politicized by political parties, which could weaken the integrity of the nation as well on caste lines. So there are those who oppose caste census and reservation based on caste census. On the other hand, there are those who are supporting it, calling for similar census like Bihar, based on which reservation can be extended. So now, the perfect case to look at here would be Tamil Nadu. Tamil Nadu also has an experience with caste census, and Tamil Nadu's experience shows that a caste census may not lead to an increase in reservation for OBC classes, as it has been feared that caste census will automatically increase reservation for OBCs, right? This fear is not entirely valid according to the article, because the case of Tamil Nadu shows that despite the caste census that was done many decades ago, reservation has actually declined for OBCs. The Second Backward Classes Commission in the 1980s had recommended a reduction in reservation percentages for different OBC classes. So this addresses the fear, and the article is supporting caste census around the country, because the deserving castes, which are really backward in terms of their social and educational backwardness, they could be provided the benefit of affirmative action or the quota system or reservation in education and in public employment. Now, if you look at the Indian Constitution, right, it provides for right to equality under Article 14. And as a continuation under Article 15, it prohibits the state from discriminating on the lines of caste, religion, race, sex, and place of birth. But however, there is an exception. There is a reasonable restriction at Article 15 that allows the state to provide for positive discrimination, which is nothing but affirmative action, reservation, for socially, educationally backward classes. So this covered the scheduled castes, the scheduled tribes, and later the OBCs as well. Now recently, the EWS quota of 10% reservation has been introduced for economic backwardness, for those communities which are economically backward. So this is a new addition which has happened in the last few years. Similarly, under Article 16, the discrimination in terms of public employment is prohibited. The state can't discriminate with regard to public employment on the grounds of caste, religion, etc. However, there is an exception here as well. Positive discrimination can be done with regard to public employment for government jobs. The government can introduce affirmative action and provide reservation for backward communities, socially, educationally backward communities, and now with EWS quota for economically backward families as well. Is that clear? Now the question is, what should be the amount of reservation in the country with regard to education, then with regard to government employment, that is government jobs? What should be the ideal percentage of reservation without compromising the rights and the merits of the general category candidates? So this is where the Supreme Court has laid a cap to address this issue in 1992, following Mandal politics, following the Mandal Commission recommendations, which introduced 27% OBC reservation, right? It increased the reservation provided in India. Until then, It was just scheduled caste, scheduled tribes which enjoyed reservation, along with few other small classes like disabled, former defense personnel, etc. But with OBC reservation that was brought out in late 1980s through Mandal politics, right, introduced OBC reservation of 27%, and in many states the reservation crossed 50%, which would compromise the rights of the general category candidates. So to address the issue, in the landmark Indira Savni judgment, in the Indira Savni case, also called the Mandal Commission case, the Supreme Court established a golden rule with regard to reservation. In the Indira Savni judgment, the Supreme Court upheld the constitutional validity of OBC reservation. It upheld the very concept of affirmative action, which is useful to uplift communities like SCs, STs and other backward classes. But at the same time, it placed a cap, a maximum cap of 50% reservation. The Supreme Court said reservation cannot cross 50%, the other 50% should be made open for general category candidates. Now, in several states, especially in Tamil Nadu, reservation had already gone beyond the 50% mark. Because of the caste census Tamil Nadu had conducted decades ago, and the recommendations of various commissions, the backward classes commissions, Tamil Nadu had provided reservations to the tune of 69%. Now with Indira Savni judgment, reservation in Tamil Nadu was under threat, which meant the Tamil Nadu government had to scale down reservation, right? So to avoid the judicial scrutiny and judicial review, Tamil Nadu passed a law to safeguard its 69% quota by placing it under the 9th schedule of the Indian Constitution. So Tamil Nadu is one of the states in India where reservation is beyond the 50% cap, which was mandated by the Indira Savni judgment. Now, what can you infer from this? You can infer from this that even if caste census is conducted, it may not necessarily lead to increase in reservation. It may not lead to any further increase in reservation beyond the 50% cap. Because caste census can be a very useful social and economic and governance tool. It can help identify the caste divisions, the backwardness triggered by caste, which has been the bane of India. Right? The genuine communities which are genuinely suffering from caste discrimination, right, which have been left behind from centuries of caste-based oppression and discrimination, they can truly benefit through caste census. Because with regard to reservation, the fear is that many communities have misused it. As it has become an electoral political issue, reservations have been extended almost indefinitely, and even those families which have already benefited, right, who have entered the creamy layer, even they have continued, cornering the benefits of reservation. Within OBCs, within SCs and STs, only a certain section have cornered the benefits, while still many are left behind. So instead of providing reservation for all the communities which have already been uplifted, it's better to target the reservation more specifically towards the real backward communities. That is where a caste census can help. It can help identify the truly backward classes, right, and remove reservation for those who are no longer eligible, who have already been socially uplifted. So that is why there is a strong demand for a caste census to be held, like it happened in Bihar. But there's a strong opposition here because there is a fear that if caste census is done and reservation is increased, it might lead to the breach of 50% cap reservation. So the article is saying that this need not be a fear which prevents a caste census, because Tamil Nadu shows that despite having 69% reservation and despite having a caste census, reservation has actually reduced following the caste census. That is the argument the article is using to justify the need for a caste census. But however, this can be a politically divisive issue, right? And there is always a possibility of this being misused electorally for populist gains by various parties, regional and national parties. So that is something you understand from this important article. Now coming to page number 1, we have a shocking development coming from Qatar. Qatar is a good friend of India. India-Qatar share very, very good relations. We actually import a lot of energy from Qatar. Oil and gas imports are quite strong between India and Qatar. So we do have a very strong trade relationship built on energy security. There's a very strong Indian diaspora as well in Qatar. You have a few lakh Indians residing, working in Qatar. They formed a strong cultural, economic bond. Despite the close relations, there was a shocking development that happened last year. Right? There's not a new development which happened just yesterday. Right? Of course, what happened yesterday has taken India by surprise. But this is something that was building up from last year. In 2022, 8 former Indian naval officers who had retired from the Indian Navy, who were working for a defense company called Dahra Global. They were working as consultants, as military trainers for this company, which was owned by a Omani military officer. It's based out of Oman, this company. It's a defense contractor, basically providing training services and consulting services. All right? It was acting as a military consultant, helping in training the armed forces of other countries. So that was a service being offered by this private defense company. It was headed by a former military officer from the Oman Armed Forces. It was primarily based out of Oman. It had won many military contracts in Qatar. It was involved in training Qatar's armed forces, particularly the naval forces of Qatar. So in this company, there are many former Indian soldiers who are employed. Many former Indian soldiers from Navy, Army, Air Force who have retired from service. They look out for corporate opportunities like this. So many Indian soldiers who are working for Dahra Global, this Omani company, and providing military training and consultancy services for Qatar's armed forces as part of the contract. But last year, 8 former soldiers from India, naval soldiers, they were arrested by the intelligence and security agencies of Qatar. The charges have not been made public till date. Publicly, we don't know what the charges are, why they have been arrested and detained. They were even kept under solitary confinement. And for many months, Indian officials in Qatar weren't given consular access. Providing consular access is a mandatory requirement under the Vienna Convention on Consular Relations. Under the Vienna Convention on Consular Relations of 1963, giving consular access to our diplomats and consular officials is an international obligation. Is that clear? See, in foreign countries, if Indian nationals get arrested for any crime, for any reason, it's a mandatory requirement that the other country, the other government, has to provide consular access so our officials, our diplomats from the embassy and consulates can meet the detained Indian citizens and provide legal access to them, provide legal help so they can fight their case under the law of that country. Is that clear? That is a mandatory international requirement. So after a few weeks, Indian officials were given consular access by Qatar. In the recent months, Indian diplomats and consular officials from Qatar have met the retired officials who are in jail. The family members were also given some access, limited access. And since then, India was fighting for the release of these officials, these former Indian Navy soldiers. Now, speculative reports are suggesting that the Indian soldiers, the former soldiers, have been arrested on charges of espionage. There are several reports indicating that most likely the soldiers were working for Indian intelligence agencies, or maybe they were working for Israeli intelligence agencies. So this is a very speculative area. I would not like to venture into this because it would just be a conspiracy theory without any evidence. Or even if the reports are true, there's no way we can verify this ever, because any such operations would remain classified for a long period of time. India has remained very silent on this aspect of the allegation which has come up. It's been said, it's been alleged in the media, there is some pointers indicating that maybe India's RAW and Israel's Mossad were involved in some kind of a joint operation using this company to spy on Qatar. Or maybe it was just Israel without India's involvement. Even that is a possibility, where Israeli intelligence Mossad was working through Dahra Global and using the company to spy on Qatar. All right. So why would either India or Israel be interested in spying on Qatar? According to these reports, Qatar was procuring a stealth midget submarine, a miniature stealth submarine from Italy, which would significantly boost Qatar's maritime security capabilities. Now, as you know, Qatar has a history of supporting Hamas, Hezbollah, Muslim Brotherhood, and other terror organizations against Israel. So Israel does have its suspicion about Qatar, its doubts about Qatar. So maybe Israel would have been interested in monitoring the growing naval capabilities of Qatar's navy, right? India also may have been interested, given that Qatar is very close to Pakistan, right? There is a possibility that India would have feared Pakistan getting access to the stealth midget submarines, which are almost undetectable, which is of Italian origin. Again, these are all speculative reports. Whatever I've mentioned here, these are all media reports. There's no confirmation on this. Whether these Indian officers were involved in espionage or not, it can't be confirmed at this stage. But one thing is clear, that the detention of Indian naval officers is indeed a major concern for India, right? And now, Qatar has delivered a bigger shock yesterday. It has delivered the death penalty to all of them. So now essentially it confirms that it was espionage charges which were pressed on them. Because see, Qatar is an authoritarian country, right? It's authoritarian monarchy. It's only charges like espionage, acts against the security of the country, which attract such strict punishments like the death penalty. So if foreign workers like Indian retired naval officers have been delivered death penalty, right, without making the charges public, most likely it's on the grounds of espionage and threat to Qatar's security. So now, what options does India have to secure the safety of the former Indian soldiers? This becomes the big issue. Because we have dealt with one such incident recently. You might have heard about Kulbhushan Jadhav. Just a few years ago, Kulbhushan Jadhav was a commander in the Indian Navy. He had retired from service. He was a former naval commander. He had taken voluntary retirement. And he had joined the private sector, and he was working at Chabahar port, the strategic Chabahar port in Iran, which has been built by India. So Kulbhushan Jadhav was running his own company. He had a maritime business after his retirement from the Navy, and he was operating out of Chabahar port in Iran. But all of a sudden, he was arrested in Pakistan. And Pakistan alleged that Kulbhushan Jadhav was involved in espionage and terrorism against Pakistan, as he was an agent working for research and analysis wing. This was the accusation Pakistan brought up against Kulbhushan Jadhav. So following this, Pakistan also had denied consular access. It didn't give consular access for a long time. And India took up the case at the International Court of Justice, the ICJ. ICJ is a UN organization. It's a primary organ of the United Nations. It looks at disputes between two states. The ICJ can take cases between two UN member countries. Alright? So India approached the ICJ to secure justice for Kulbhushan Jadhav and filed a case against Pakistan for not providing consular access to India. Following ICJ's intervention, Pakistan was forced to give consular access. So Indian consular officials and even Kulbhushan Jadhav's family were allowed to meet him in Pakistani jail. Eventually, even Kulbhushan Jadhav was awarded the death penalty. Right? So India right now has appealed against it at ICJ, and we have got a stay order. Now please remember, ICJ rulings are binding. It's legally binding on UN member states, as it is a primary organ of the UN. Under the terms of the UN Charter, right? The orders of ICJ are legally binding on all member countries. So through ICJ's intervention, we have got a stay order as of now from the execution of Kulbhushan Jadhav in Pakistan. Is that clear? So that is the legal option we have exercised, the diplomatic legal option. But however, Kulbhushan Jadhav remains in a Pakistani jail, continues to suffer in Pakistani custody. Again, here as well, there are strong reports indicating his involvement with India's intelligence agency, but again, it's largely speculative. The speculative reports point out that most likely Kulbhushan Jadhav was kidnapped in Iran, as he was known to have links with India's RAW, and Pakistan's ISI engineered his kidnapping with the help of local terror groups and organized criminal cartels. That's what reports are pointing out. So most likely Pakistan's ISI, which figured out that Jadhav was working for India, working for RAW after his retirement, right? He was allegedly kidnapped with the help of local terror and criminal cartels and sold to the ISI, which later showed his arrest in Pakistan and charged him on the grounds of espionage and terrorism. These are what media reports are indicating, right? But India is fighting this case, trying to secure justice to Kulbhushan Jadhav. But in such a complicated case, right, your diplomatic options will be limited, especially if the other country is not cooperative, right? So what can save someone like Kulbhushan Jadhav or even the Indian naval officers in Qatar is a showing of mercy or providing clemency by the other country. Because the legal process would be very complicated. There's no way that the legal process can be overturned, right? Apart from ICJ's intervention, where the death penalty can be stayed or maybe consular access can be demanded. Apart from that, it can't secure the release of these Indian former soldiers who are, detained in foreign countries. Now, the similar challenge comes up here in the Qatar espionage case. Now, there are 8 Indian soldiers right now on death row. Qatar is known to execute prisoners on death penalty, right? So, India has a very narrow window to act. India will be exploring all the options available. India has made it clear that we will exercise all the legal diplomatic options, right? Given that Qatar is a close friend, unlike Pakistan, we might try to work our diplomatic influence. India might rely on close partners like US, UAE and Saudi Arabia, all of which have tremendous influence on Qatar's government. So maybe through US, UAE or Saudi, we'll try to bring some diplomatic influence to push Qatar to release the Indian soldiers, maybe out of mercy or clemency. Is that clear? Or maybe work out an arrangement where they can serve the jail term in India, right? Something like that. So we will explore all the legal diplomatic options, and if required, India will again go to ICJ, International Court of Justice, to secure justice for Indian soldiers, former soldiers who are currently serving the death penalty in Qatar. So this does bring up a very important issue in international relations on how does India ensure safety and well-being of the community abroad, of Indian nationals abroad, especially if they are former soldiers accused on espionage charges, right? If the speculative media reports are true, it also raises very disturbing questions about the failed intelligence operations. If at all, right, hypothetically, if at all any of these cases, be it Kulbhushan Jadhav's case or the case in Qatar, if at all has an involvement of India's RAW, it raises questions about the operational tactics, the tradecraft of Indian intelligence agencies, right? You can't have so many intelligence officials getting detained and compromising their own safety and the operational safety as well, if the reports were to be true. So these are the big questions that come up. Of course, we'll never find complete answers to this. But however, at least for now, ensuring the safety, the well-being of these Indian former soldiers would be the topmost priority for the Indian government. So this completes my detailed discussion of all the big articles in today's newspaper. Now let's head towards the prelim section. We'll take a look at 4 important articles. On page number 1, the Hindu carries an image of a naval exercise which is underway in the Gulf of Guinea. You can see a helicopter which is preparing to land on the deck of a naval ship. This image is taken as part of the first ever India-European Union naval exercise. I hope you know India and European Union, we have very, very good defense and security relations, and we are starting the first ever naval exercise between India and the EU. So this exercise is taking place in Gulf of Guinea, where Indian naval ships, INS Sumedha and an offshore patrol vessel have joined the military exercises with other vessels from Italy, France, Spain and other members of European Union. Now, what kind of question can you expect from here? What points are relevant for the exam? See, this is the first ever India-EU naval exercise. So this marks a further improvement in our defense and security relations. Please note, we already have very good ties with EU. All right? The EU is a regional grouping of 27 European member countries. We have very good defense, strategic, economic and cultural ties with the EU. So we are taking this one step ahead by carrying out the first ever India-EU joint naval exercise. We even have bilateral naval exercises with France, with Italy, right? We have bilateral naval exercises and other military exercises as well between our armies, air force, etc. But for the first time, with an entire regional group like European Union, right? India is holding the exercise. Again, to be more precise, it's not the first time with a regional group. Recently, India held a similar exercise with another regional group. With an entire regional grouping, we held a naval exercise. All right. Now, please find out which regional group was this. This is a small homework for you. All right. This is the second time actually that we are holding such an exercise with an entire regional grouping. That is with European Union. All right. Just few months ago, we held a similar exercise with another regional group, where with all the members of the regional group, we held a naval exercise. So find out which regional group is that and mention that in the comments. All right. So we do have bilateral close defense relations with EU members like France, Italy and others. And this is the first time we are conducting such an exercise with the entire EU, right, in the Gulf of Guinea. Now, the point is, where is Gulf of Guinea located? That can be a map-based prelims question. You can see here in the map, this is where Gulf of Guinea is located, in the Atlantic towards Western Africa. So countries like Ghana, Benin, Togo, Nigeria, Cameroon, Equatorial Guinea, Sao Tome and Principe, Gabon, Cote d'Ivoire. These are the littorals, the rim countries of the Gulf of Guinea. All right. So in this region, India and EU member countries have held the drill as part of upholding their commitment to the Yaoundé architecture. This could be another prelims question. Because of the naval exercise, UPSC can ask a basic question on what is the Yaoundé architecture. This is a maritime security architecture created by the regional countries in West Africa. Some of the countries here in West Africa around the Gulf of Guinea, they have a regional maritime security initiative called the Yaoundé architecture. So India and EU both are committed to upholding the maritime security of West African countries as part of the Yaoundé architecture, and we are committed to upholding the principles of the UN Convention on the Law of the Sea. Right? So that is why this naval exercise has been held in West Africa in the Gulf of Guinea to support the Yaoundé architecture and to improve the maritime security of West African countries. All right. Following the exercise, Indian and European officials from the respective navies have shared the knowledge with Ghana as well, which is a friendly country to us. We have deepened our defense ties with Ghana, the West African country, where Indian naval officials and the EU naval officials have shared the operational knowledge they experience with Ghana to help Ghana strengthen its maritime security. So this points out India's growing defense profile as well in Africa as far away as West Africa, right? Now coming to the next article, on page 14, we have an article referring to the Anaimalai Tiger Reserve. The article refers to a rewilding project where tigers are being reintroduced in the wild, and it becomes important to know more about the Anaimalai Tiger Reserve. This important tiger reserve, which is a part of Project Tiger, which is managed by the National Tiger Conservation Authority under Project Tiger, it's one of the important tiger reserves located in the state of Tamil Nadu. You should know the basics. Anaimalai Tiger Reserve is in Tamil Nadu, in the Coimbatore district and Tirupur district of Tamil Nadu. That is where it is located. It's part of the Anaimalai ranges of the Western Ghats. I'm sure you know about the Anaimalai ranges of the Western Ghats. This is where the Tiger Reserve is located, in the Coimbatore and the Tirupur district. It spills over into Kerala as well. You can see the Parambikulum Tiger Reserve of Kerala here. It adjoins the Parambikulum Tiger Reserve of Kerala. Alright, so that is where the Anaimalai Tiger Reserve is located. It's a protected area. It's a protected area that was set up under the Wildlife Protection Act of 1972. Right? It has been a wildlife sanctuary, a national park, now elevated to a tiger reserve under Project Tiger, managed by the National Tiger Conservation Authority. You find many threatened species here, not just the tigers. You also find other threatened species like leopards, elephants, the lion-tailed macaw. Is that clear? Elephants, lion-tailed macaws, leopards are also found here, along with a lot of exotic biodiversity in the region. Next, on the same page, there's an article referring to the Ethics Committee of the Lok Sabha. A major controversy has erupted in the Lok Sabha with regard to MP Mahua Moitra from the Trinamool Congress. She has been accused of taking cash, taking bribe for raising queries in the parliament. The MP is facing a very strong allegation of corruption where allegedly she has taken cash for asking questions in the parliament on behalf of interested parties. So this particular scandal which has broken out has been referred to the Ethics Committee of the Lok Sabha for further investigation. So as a result, the Ethics Committee itself becomes important for your exam. In the Lok Sabha, the Ethics Committee was constituted in 2000 under Speaker GMC Balayogi. In fact, in late 1990s itself, there was a discussion within the Indian Parliament that we should have an Ethics Committee to ensure ethical conduct of the MPs. In 1996, the Rajya Sabha took the first step, following which an Ethics Committee was set up the next year in 1997. So Rajya Sabha has an Ethics Committee which functions from 1997 onwards. It functions under the chairperson of the Rajya Sabha. A similar Ethics Committee was set up in 2000. It was a temporary ad hoc committee which became a permanent feature of the Lok Sabha in 2015. From 2015, it's been a permanent feature of the Lok Sabha as well. So the Ethics Committee looks after the ethical conduct of the members of the House. Any cases of unethical conduct, including cases of corruption, bribery, is dealt with by the Ethics Committee. It provides recommendations and frames a code of conduct for the MPs to uphold the integrity of India's legislature. Is that clear? The members of the Ethics Committee in the Lok Sabha, they are appointed by the Speaker for a 1-year period. The chairperson is usually from the ruling party, that is the convention, and members from other opposition parties are also appointed. So Speaker of the House, Speaker of Lok Sabha makes the appointment for a period of 1 year. Now, what is the procedure for making a complaint against an MP? On what basis can you question the ethical conduct of an MP? See, other MPs or even any citizen can bring up this complaint. Any individual, any common individual can bring up the issue, but it requires the support of an MP. Let's say you as a citizen, you have some evidence. You have evidence to show that a particular MP is involved in corrupt acts. Now you take the evidence, approach another MP in the House, and with the help of the MP, you file an affidavit, raising the complaint, asking for an inquiry. Alright, it cannot be false, frivolous or vexatious. You can't fabricate the evidence, you can't simply make blanket allegations. But with evidence, if you approach the Parliament with the help of an MP, the MP can raise your complaint on your behalf and bring up these allegations of misconduct on a certain MP. Alright? The other possibility is the other MPs can do it on their own. The existing MPs can bring up the complaint. But again, there should be some prima facie evidence. It can't be just an allegation. It can't be just a frivolous complaint just to target and tarnish someone's image. That can't be done. Such complaints will not be accepted by the committee. Right? If the Speaker has to recommend the complaint to the Ethics Committee, the complaint should have some merit, whether raised by other MPs or by a individual with the help of an MP. It should have some substantial basis. There should be some prima facie evidence to show unethical conduct. Only then it will be taken up for inquiry by the Ethics Committee. Right? The Speaker will recommend the Ethics Committee to look into the case. So the committee's report will be presented to the Speaker. It will be presented in front of the House as well. There can be a half-an-hour discussion also on the report of the Ethics Committee. Is that clear? So these are some basic points you need to remember about the Ethics Committee of the Lok Sabha. Now coming to the last article in today's newspaper, there is a mention of the National Green Hydrogen Mission, which is a very ambitious renewable energy program that has been launched by the Modi government at the start of this year. In 2023, in January 2023, the Modi government unveiled a very ambitious initiative, the National Green Hydrogen Mission. The goal of National Green Hydrogen Mission is to ensure that India becomes a manufacturing hub for green hydrogen. As you know, green hydrogen is considered as a clean, renewable form of energy. It can help in reducing greenhouse gas emissions. It can tackle pollution and emissions. So it's in line with our commitments to the Paris Agreement, right? It's a part of our climate action efforts to tackle global warming and climate change. So green hydrogen, which is synthetically produced through electrolyzers, right, is seen as an alternative fuel, a clean alternative fuel, a renewable form of energy. It can not only reduce emissions and bring down our carbon footprint, but it can also save precious foreign exchange by reducing our fuel imports. Our fuel imports can go down. Our energy dependency on fossil fuels can reduce, which will make India more energy secure. Is that clear? As green hydrogen is an alternate fuel. So with this goal, by 2030, India wants to emerge as a major manufacturer and also consumer of green hydrogen. India wants to export green hydrogen to other countries. We want to create the industry base for that, right? So give that support for industries in India to set up domestic production of green hydrogen, achieve an annual production of at least 5 million metric tons with 60 to 100 gigawatts electrolyzer capacity, and ensure that we consume the green hydrogen in India for energy purposes and also export it to other countries, which will transform India into a green hydrogen hub. That is the focus of the National Green Hydrogen Mission. But according to the article, this mission carries its own risk, because the large investments which will happen in the industry, the increased production, manufacturing, can further contribute to pollution and emissions, which has not been accounted for. The article is pointing out that based on studies, it has been shown that clean renewable energy may not be as clean as it is. Like for example, solar and wind is usually promoted as clean energy, or even electric vehicles are promoted as clean vehicles. But if you look at the collateral aspect, if you look at the whole manufacturing process, the resources, minerals needed for the new technologies, right, the large industrial base which has to be created, it will further contribute to deforestation and as well as more emissions as well, right? So that is something which is not being accounted for. So the same exists here with green hydrogen as well, and that's what the article is highlighting. Article is saying that India's green hydrogen mission can actually increase pollution, increase emissions, if the necessary checks and balances are not in place, if the necessary measures are not taken to tackle emissions from the industry. Is that clear? So this is about the National Green Hydrogen Mission. With this, I would like to complete my discussion for today. Please take up these 2 questions for your mains answer writing practice. Write the answers, post them in the answer writing portal, for which link has been provided in the description box. Also head to our Telegram channel, because we'll have a quiz on these topics immediately after the session ends. It'll help you revise these articles again. So join the Telegram channel by using the link in the description box below. So I hope you guys liked the session today. Do let me know how it went in the comments. Do press the like button and subscribe to the channel. We'll see you tomorrow. Till then, thanks for watching. Have a good day.